Welcome everyone to Lawyers in the Corporate Space webinar. This is our second edition, and it was started to provide a mentorship platform for in-house corporate lawyers. Our first meeting, we delved into who the in-house lawyer was, the role, what it entailed, how it could be better. And today we'll be looking at the in-house lawyer as a company secretary and the role of that company secretary in corporate governance in the company. My name is Bridget Afodo. I have been a lawyer for 8 years. 3 years we started at Ntrakwah and Co. So there's no surprise that today we have Mr. Felix Ntrakwah as our resource person. And the next 5 years, I have been in-house and currently the legal manager at Senate Energy Limited. Today's topic, the role of the company secretary in corporate governance, is going to be handled by Mr. Felix Ntrakwah. He is the founder and chairman of Ntrakwah and Co, a reputable law firm in Ghana. And he has wealth of knowledge in company law, corporate practice, company secretarial practice. He also founded the Corporate Law Institute that provides training in corporate governance, among other topics, for lawyers and non-lawyers alike. Even though he is in firm practice, we invited him yesterday because of all the knowledge that he has and that he is willing to share with us today. But enough about me. Let's invite Mr. Felix Ntrakwah to introduce himself and take us through today's topic, the role of the company secretary in corporate governance. Mr. Ntrakwah, yes, we can hear you. We'd like to know a bit about you, about your journey and how you became how you got to where you are now.
Well, I began from secondary school quickly. I attended Bampunsem Secondary School, Ntrakwah Onofin, University of Ghana. And then I took employment in the Ministry of Justice, directly at the Registrar General's Department. From there, I started doing some program, training first in French.
Okay.
Then from French to specialize as a legislative draftsman. From legislative drafting to training in industrial property law and company law administration in different jurisdictions. I studied arbitration at the ICC Business Law School in Paris. Over the years, I have done a lot of training programs, looking at various aspects of the practice, including even a postgraduate diploma in international tax law. Because the idea is that sitting in the boardroom as company secretary, as lawyer, as director, I realized that, as they say, education has no end. So every year I try to spend money to go abroad and train. So from finance, banking, and so on and so forth. I was at the Registrar General's Department for a few years. The plan was that I was not going to stay in government employment for long because I knew what I wanted.
Okay.
I wanted to go into private practice as a lawyer. It just happened to be a coincidence that when I was being interviewed for employment as an assistant state attorney, I was asked about the areas of law where I thought more work needed to be done. And I mentioned company law. And that on my own, I had started preparing myself. And I was teaching company law already. So the Solicitor General then, now Dr. SKB Asante, was the chairman of the interview panel. He said, okay, will you hear from us? I was written to report for duty. Then when I went there, I was given a letter, report at the Registrar General's department. I never had that one in mind. So how come? Then the chief director said, the Solicitor General said you should go there because you'll be useful to them. So that's how I got there. It was that I got a fellowship to go and train as a legislative draftsman, a fellowship to go and train in company law administration and intellectual property.
Well, what we would like to know also about Corporate Law Institute, you starting it.
The idea of Corporate Law Institute came about when I gathered from outside Ghana that lawyers did not end their education merely by acquisition of degrees and professional certificates. Lawyers outside Ghana were engaged in continuous education. This was lacking in Ghana. So I thought that I should replicate that here, because you go and meet lawyers speaking different languages, training themselves, picking ideas. And I remember during my training in international commercial arbitration in Paris, the professor used Ghana's Arbitration Act as an example and said that in the whole world, it is only Ghana that had been bold to define arbitration.
Okay.
But whether you like the definition or not is another matter. And what was the definition? An agreement by two parties to resolve their dispute outside the High Court.
In the chief's palace.
That sounded too funny. Luckily, I had a law, I looked at it and the professor was right. I said, but why are we sitting in Ghana content with our degrees? Somebody must do something. So that's how I started. I incorporated the company and I wanted lawyers to participate. So the first seminar was on directors' fees, directors' remuneration, and directors' emoluments in corporate governance. Very well attended at the British Council Hall. And I had a form for participants to fill if they were interested in becoming members of the Corporate Law Institute. Widely distributed. At the end of the day, I got no one. It told me something. So the objective of having so many people involved to keep the institute going was defeated from day one. So it remained with Ntrakwah and Co. And we've been using this to train, to the extent of even bringing professors from universities abroad. Monday to Friday, the material you collect, the training you receive was more than maybe a year's appearance in the classroom. Foreign exchange difficulties made it impossible for us to bring in the foreign experts. So we've been doing it internally. And it's not just for lawyers. We do programs for all kinds of professionals and executives.
Okay. Now that those of us who do know about Corporate Law Institute, now that we've heard about it, I hope that we'll endeavor to participate whenever we see any training that's being circulated. So thank you so much.
I think there's a program coming on, is it November? Company secretarial practice.
Oh, okay, this is apt. So please, after today's webinar, if you think you need more training, and certainly you will, because this this is all that we can do in about an hour and a half, but it would be good to go for the training in November. Yeah, Mr. Ntrakwah, you were saying that you have served as the assistant registrar of companies, and
Yes.
having sat in such a unique seat, what were your experiences and in terms of the way companies were being run, what companies were doing? And I'm also interested in why you would be in such a seat and then you would leave.
Well, I'll tell you my first day at the department. I took my letter from the Solicitor General to the Registrar General. The Registrar General was so furious. So he wrote immediately to the Solicitor General. He wouldn't admit me because, as he put it, the appointment of Mr. Ntrakwah is a supernumerary. So for 2 weeks, I reported for duty, no office, no chair. I would pace the floor a bit and go back to the Attorney General's department to complain. But I don't regret being in the department, and for that matter, government service. I learned a lot. It was there that I realized that there was a vacuum in the system. A young man, fresh in the business, seeing big-time accountants and lawyers coming to me for opinion. It strengthened my desire not to remain in government employment, but rather to go out quickly and fill in the vacuum. As I said, my idea when even in the university was to come out and practice company and commercial law practice. That is why I started with teaching company law right from school. The training at the Registrar General's department also helped me. I took the advantage, studied the issues there and in companies. I said, I'm better off leaving government employment and going to start something on my own. I thought I had made a very good decision. And 6 months after I left, coup d'etat.
Sorry about that.
So who was coming to do business here and be looking for a lawyer with, expertise in corporate governance or company law practice? That was the difficulty. You could see that from the complaints that people make. There is a lot of ignorance in the system, inexperience in the system, and people also not wanting to go by the rules. In matters, I realized that there were petitions here and there, and that people were not making use of the contents of the Companies Act. They had complained that we are not having general meetings, but the registrar has the power to compel companies to have their annual general meeting. And I witnessed some. They were called, they went to the conference room, and the registrar would be seen pacing the floor to ensure that they had the meeting, took their decisions, and went out.
So is there any company secretarial experiences that you'd want to share with us?
Well, 1 or 2.
Yes.
I remember minutes taken when in the course of the meeting, directors virtually exchange blows. So I wrote down, in view of the altercation which ensued, the meeting came to an abrupt end. Then the next meeting, second, who told you to write this? Did you say we were fighting? If it's fighting you want to complain about, you will see more. Remove it and say that the chairman asked for a vote for the meeting, and upon the vote, the meeting was declared closed. How? Well, this is what we want. And let me give you the example of a managing director wanting the company secretary to be sacked. This was an agric, a farm, commercial farm. A new MD comes. Can you tell us, the board, any plans you have for us? You've been around, you've seen a lot of things. Then the managing director, a foreigner, he said the first thing will be to have the farm manager as the company secretary. This being a farm, we don't need a secretary in suit.
Yeah. The secretary in suit won't understand the business.
You know, this is farming.
No.
Why do you do a meeting in suit? But the directors knew better. Before he could put anything down, he had been fired. They said, but if your concern is this, then you don't even understand your role as managing director. This is an international firm. If we have a lawyer as a company secretary, we are all protected. And what would you say going to a meeting as company secretary? Every member of the board was invited. They all said they were attending. The invitation went to different countries: Cote d'Ivoire, France, Netherlands, Ghana, UK, including the nominee of the creditors of the company, whose presence was required for a quorum. Then before the meeting started, the man who had said earlier that he would be attending sent a message: proceed with the meeting, regardless of the absence of a quorum. I am not coming.
Okay.
So you have directors who have come from far and near to attend a board meeting. Now there is no quorum if he's not there. And then they all turn to you, company secretary, what shall we do? If you were in my position, what would you do? I have been seeing some corporate governance papers with the suggestion that, oh, in that case, those persons should constitute themselves into a committee of the board and take decisions. I did not do that. I just advise the directors, let the MD tell you the urgent matters he needs to look at. Let him go and take action on them and come for ratification, instead of we claiming to have constituted ourselves into a committee of the board. If there is no quorum, is the board in session? Is there a meeting? Who appoints committees of the board? So that's what we did. So MD took note. We reassembled a few months later. The one who refused to come was there. MD asked for ratification. Then it was everybody, yes, yes, yes. He alone said no, but he was there, therefore he lost the vote. So the company, the managing director took his decisions, implemented them, they were ratified by the board, instead of members illegally constituting themselves into a committee of the board.
I think that advice is very interesting because it's furthered the business of the company,
Yes.
which is very important. That our lawyers constantly putting a plug in the wheel. Do we understand the business? Do we understand the needs of the chief executive officer, the managing director, in having the company running? So I think that was very business-minded advice, so that the business of the company does not stall I would continue. That's some very good advice to share. So yeah, Mr. Ntrakwah, do you have any books that you'd like to tell us about that would be useful for us to purchase?
Purchase. Well,
Yes,
there's
please.
one, I have written other materials, but there's one you may need. It's obligations, defaults, and penalties under the Companies Act.
Okay. Okay.
So it's for the company secretary, whether you are a lawyer or a non-lawyer. It's for also directors. Whatever you have to do in terms of compliance is in here. And then the penalty for failure to do. There's also 1 or 2 pages on the duties of directors. We call reminders in the book. Short sentences from what directors are supposed to do.
Okay. So I'll ask for information on how we can purchase copies, and then we can put in the chat box for everybody else to see.
But together with my professors who taught me in the first year in the university, Professor Fiajo and Professor Justice Dateba.
Okay.
Yeah, we putting together material that will be useful to all of you. At least the chapter on meetings is authored by me.
That's nice. So to go to the crux of today's topic, what most of us, I'm sure, can't wait to hear about. Mr. Ntrakwah, who is the company secretary?
This is an interesting question. Until the Companies Act 2019, there was no statutory prescription of the role of the company secretary in the Companies Act. So before we come there, you should look at what the secretary does.
Okay.
You are involved in the preparation for company meetings. The link between management and the board. You are more or less a liaison officer preparing the company for meetings. You pick from management, you give to the board. You pick from the board, you give to management. So agenda preparation, you are involved. Notices, you are involved. And the company secretary is also present at the meeting. The company secretary must make sure that everything is set before the meeting takes place. The location, materials, whatever. The company secretary must attend to the needs of directors at the meeting. The company secretary is not a messenger. If you want to know more about the company secretary, you can compare the secretary to the board chair. Compare the secretary to the managing director. Then you realize that the company secretary's position is statutory. If a company does not have a company secretary for 6 months, there will be a penalty. Every company should have a secretary, but not every company should have a board chair. And not every company should have a managing director. This is to bring out the importance in the role of the company secretary. Yeah. It's by law. Now, the Act specifies the secretary should take notes at the meeting and make out minutes from the notes. The secretary should advise the directors as to their responsibilities as directors regarding new laws that are passed and also compliance with existing laws. But it goes beyond that. After the board has finished the meeting, decisions are taken. I have heard it said a few times in some places that it's the board chair who must communicate. Who is the board chair after a board meeting? I once said, as a chair, when you finish the board meeting, go home. And somebody wasn't happy at all. So why should I go home? Say, go home. What are you doing on the premises of the company? Board chair. Your work is over. So the secretary is the one who will communicate the decisions of the board to those who must know about them, to management, and for management to pass the decisions on to other officers of the company. Sometimes the communication will go from the board to outsiders, is the company secretary. Except that for some decisions, the board itself may decide, given the addressee of this letter, it should be signed by the managing director, or it should be signed by the board chair. Besides, the company secretary's responsibility is to file the returns. And I mean statutory returns. Even though there's room for signing by directors, the officer who is best prepared for this job is the company secretary. Minutes writing, a major responsibility of the company secretary. Sometimes this is where the embarrassment of the company secretary can come from.
That's very true.
And those who often criticize the company secretary, I bet you give them the opportunity to write the minutes and you'll be shocked. They cannot do it, but they are capable and able to criticize. Now, you will see how important this role is on the rare occasion when the managing director has to be fired. The directors are all dependent on the company secretary. Managing director becomes so sober. Even making inquiry from the company secretary is a problem. And this could be the person who was browbeating company secretary at the least opportunity. Because the director said, what shall we do? And then secretary has to advise them. But I think it is not enough to go by the statutory rules. I see it also as the role of a person who must be continuously studying all the papers that pass through you. They may be technical papers. You must see that the rest of the people are going to depend on you. So you have to read. Don't just pass the papers. Read them. The advantage in doing that is that, in case you may not be aware, it is one office that prepares you to take over from the managing director. In the past, when we had a lot of statutory corporations in Ghana, if you check, a number of them, their company secretaries eventually became managing directors. So the company secretary is used to all the processes, how members are prepared, how the board acts, how the managing director reacts to situations. You learn all. So you are not just there sitting in the meeting and taking notes. You are in a school.
Yes.
Must be meticulous. Very meticulous. Communicate effectively. Retentive memory. That if you allow your directors to continuously correct your grammar in your minutes, you are in big trouble. Initially, you may make mistakes. It's normal, but you have to learn very fast.
Yeah, that's true.
If you're not lucky and you meet a board chair who doesn't know the left from the right, you become the de facto board chair.
Mm.
Because everybody is going to depend on you.
That's true.
You must learn the industry, the business of the company. You must learn it.
If I can chip in here, I remember one of the first few meetings I attended was an insurance company, and we were talking about the life fund and things like that. And if you don't understand the business, then you struggle to produce the minutes.
Yes.
Because you don't even understand it, you don't get the points, you don't get what they're talking about. So yes, it's true that it's important that you understand the business of the company in order to best capture the minutes of their meetings.
Yes. And one thing that is often ignored or even not known is the fact that the company secretary must study the characters in the boardroom. Who is this man or this woman? So the company secretary and also the board chair must take time to study the characters in the boardroom. There are those who speak in the boardroom and you know it's not getting anywhere. And this is not to say you should stigmatize people, no. There are the knowledgeable and experienced directors whose contribution will be a joy even to hear. When they have finished speaking, you almost have your minute. You don't have to struggle.
Yeah.
They are concise. They go to the point. They display skills. They make your work easy. So if you haven't studied them, you'll be writing a lot of things.
Okay, then the next question is, what is corporate governance?
Corporate governance. I say that it's no longer a matter for the boardroom. It is more on the street, the radio and television. And those who have never attended board meetings even claim to know it better than those in the boardroom. As I've said it, you pay attention to the radio and television and the comments people make on decisions made by directors. Here we are talking about a system. When you talk about corporate governance, some people will go back to the UK so-and-so committee. That's not it. This is one jurisdiction, how they went about this. We have always had a Companies Act since 1963 with the duties of directors specified. So we are talking about a system by which a body corporate is managed. System implies organization. It implies rules, regulations by which body corporate is organized. And then when you talk about corporate governance or good corporate governance, then some adjectives appear.
Yes.
You have transparency, accountability, integrity, all of them. You'll also be talking about the work of the board of directors and the work of the general meeting. The role of the company secretary will come in. This is what generally we know. But hardly do we talk about corporate governance in practice. If you are in the boardroom, how do you practice corporate governance? Because you are talking about a body corporate, let's say a company, an artificial person acting through individuals, but by law, the power of the company is distributed among the board of directors and the general meeting. So you have these two as the main bodies, or you call them primary organs. But when it comes to the exercise of the power, you have three primary organs. You have the general meeting, you have the board of directors, and the managing director. It is only the acts of these three organs that are the acts of the company. So, we sometimes confuse that any director, I dealt with somebody who is a director, and therefore the company is bound. No. If it is the body called board of directors, yes. If it's general meeting, yes. If it's the managing director, yes. Their acts are the acts of the company. The acts of other officers are not the acts of the company, unless the general meeting, the board of directors, or the managing director has held them out. Unless the director or other officer has expressly been empowered to undertake particular assignments, then that becomes the act of the company.
The question becomes, what does a company secretary do in performing this corporate governance role? You've mentioned it at various aspects of what you said, but to put it together, so if I'm making notes right now, what is my role when it comes to corporate governance in any company?
The company secretary is a major part of the system of governance. Because at common law, it's been held out as somebody who can commit the company contractually in relation to matters connected to the office of the company secretary. So in terms of governance, the company secretary attends meetings, issues notices. So you are a very responsible officer in terms of governance. I said you are a major communicator in the company. Some people say, oh, a letter from company secretary, I will not. It didn't come from the managing director. It depends a lot on what you are talking about. Yeah.
You mentioned also before that the Companies Act 2019 and now, define what the company secretary is. And I know you were part of those who reviewed the old Companies Act. So this is insider knowledge. What informed this decision? What informed defining it? And there are definitions as to which people can now be company secretaries. There are, I think, chartered accountants are there, chartered secretaries are there, or at least somebody with some level of professional experience can be a company secretary. What informed that? It must be in response to some kind of challenges that we've seen over 60 years of being with the old Act.
Yes. Ideally, we could have said only lawyers should be made company secretaries. That would have been good business for lawyers alone.
Certainly.
But in practice, that was not going to work. First, in terms of the costs, and even in terms of the need for the services of the company secretary. Mr. X and Mrs. X formed their small company, for example. First, the law says they should have a chartered accountant, professional accountant. If the law also says they should have a qualified lawyer, can they afford? Does that respond to the ease of doing business?
No.
So not everybody will require that level, because we also have types of businesses. This was likely to put people off. Then why do I form a company? Let me do my business name. So what? Proprietorship. Then I don't have to spend money on lawyers. But the work at some level can be done by people who are not lawyers. So we recognize that. But despite that fact, one important qualification is the training in company law.
Okay.
That is basic. Because without that, then you cannot do the work. So whether you are a lawyer, accountant, or not, you must be conversant with the company law. And for that matter, the Companies Act 2019. So room has been created for those who cannot afford the services of accountants, lawyers, and professional company secretaries to engage people who have some level of training, at least in company law. But like in some jurisdictions, let's say in UK, if you are not a chartered accountant, chartered secretary, you will not even qualify to be appointed company secretary of a listed company. Here, we haven't said that, but that is the practice. You will check yourself first before you apply for a job as company secretary.
But I mean, it's good to have professionals in the room. especially if the company secretary is the one to advise the board on legal things they can do. And for certain spaces that are regulated, the Bank of Ghana,
Yes.
they have their corporate governance, Securities and Exchange also have theirs. So if it's the company secretary's job to make sure that the board decisions and actions, and even management's decisions and actions when they are presented to the board, are in line with all these laws, then it is important that this person is abreast of matters and this person is enlightened in respect of the particular heavily regulated space that the person may find themselves. I have a friend she's working with a company that's regulated by SEC, and she says that she always goes with her Companies Act, which is something you always used to advise. Attend every board meeting with the Companies Act all the time. So she takes that one and then she takes her SEC rules, the conduct, so she takes them all there so that at every point in time, if she's not sure, she can refer, she can check, and then she can point it out to the board that we cannot make this decision, we can't make this decision, or we can defer and ask permission before we continue with certain things.
Yes.
So, Mr. Ntrakwah, I'm sorry, please go ahead.
Yes, this is looking at the legal and regulatory framework of corporate governance. It should be at the fingertips of every company secretary.
And I think I would like to mention, for those who don't know, if you want to know the qualification, criteria, and duties of the company secretary, you find that in sections 211 and 212 of the Companies Act 2019, Act 992. That's where you find that. You can easily get the act online if you don't already have it. So, Mr. Ntrakwah, we are looking at a scenario where the in-house lawyer is either also a company secretary or is not, but is working in close marking with the company secretary. So me as the lawyer, I know my regulations, or at least I have them at hand. I've read through them. How do I ensure that there's corporate governance? Because sometimes corporate governance sometimes goes beyond boardroom. How do I do my work as an in-house lawyer, whether I'm the company secretary or I'm not?
Well, interesting point you have raised. This is an area sometimes people will say there is a conflict. You are an in-house lawyer. It means you're already part of management.
Yes.
And you are also company secretary. It's an old practice. In those days that we had a number of factories, companies, corporations in Ghana, there was a title for that, Solicitor Secretary.
Okay.
It was popular. There was always an advert in the newspapers. The lawyer must always be able to distinguish the role of company secretary from that of the head of legal.
Okay.
So sometimes you have been part of the advice with management that has gone to the board.
Yes.
The confusion that is likely to arise now is that in the law, it's been provided that the company secretary is the advisor to the board regarding the responsibilities of directors. So supposing a decision has been taken by management and you have been part, you have advised, in the course of the discussion in the boardroom, directors are uncomfortable about it. And they ask you to give your opinion because this is your job as company secretary. How are you going to handle that? You've been part of the decision. And the way the debate is going in the boardroom, you may not have contemplated it. More or less contrary to what you have advised management to do. Now you have to advise the board on their role, their duties in terms of the law. It can be a bit tricky.
Yes.
So we have to make sure that playing our roles. If it's board secretary, if you have done it, be clear and tell the board, I've been part of this decision. Maybe let's take professional advice or that advice. It will be safer. Or you have found that something went wrong somewhere. It should allow you to check and come back. Because some directors may come to discuss the topic from various angles. Sometimes you can be embarrassed. I have seen it in the boardroom before. That means also you have to prepare very well and be able to answer questions. It may well be what a director is saying is not even in point. It is completely out of place. But because you have not prepared, you are not able to deal with the situation. But companies try to save money also. Why should a company have a whole legal department and to rent another lawyer from outside? So they try to save money. But over time, some companies have seen the need to separate. Even if the person is in the legal department, the person does the work of company secretary and not legal, to try to avoid any conflict. And it is worse where you have advised the managing director, and the managing director is also sitting in the room and receiving knocks from the directors. What are you going to say? Some companies avoid it. Legal department will do the legal work. Company secretary will handle company matters. That's it.
So for those who are currently in that space where I'm the in-house lawyer, I'm also the company secretary, but management did not inform me about a certain decision that they wanted to take. So someone was sharing a scenario where she saw an email, a decision that management wanted to do when they had sent an email to the board. So she sees the email and now she needs to advise the board that, no, we can't do this. But then the problem is she's working there and the MD is her boss in another sense, although she reports directly to the board as well. So now she was caught, in a very hard place because she needs to advise the board that this is not an action we can take. I find that sometimes even how to couch the email without necessarily making the MD look bad or making them look even mischievous, and how to make sure you're doing the right thing, because indeed, perhaps this is not something that they can do. What kind of advice would you give a lawyer in that difficult space? You are a key management person, but unfortunately, they didn't let you know.
Involved.
You were not involved in a certain decision.
You remind me of experience in the boardroom when the head of legal was called. And they said, well, the MD is my witness. All these developments took place. I was not involved. Nobody invited me. Nobody consulted me. The MD's response. I didn't make a contract, so I won't go. So the thinking is that you stay where you are. When I finish negotiation, then I can bring you in. But when I'm going through the processes, I don't have to involve you. But then here was the MD in trouble. So legal, you advise the board. But if legal happens to be secretary, it's tricky, because as secretary, if the matter is not before the board, you have no role to play.
Yes.
So if you intervene, you are creating a problem. Before the matter comes to the board, you have seen it, you have wind of it, and you want to stop it. You want to write email or memo on it in your capacity.
Yeah.
You have to watch it. But when it comes to the board and they are asking you, secretary, shall we or shall we not sign? Then you can say anything.
Okay. So we should know our place in a sense and not overstep.
Yes, don't overstep, because sometimes the MD may be playing a game, may even be promising you. I am aware of a lawyer who was almost dismissed. The lawyer said, look, even the minutes that you see, they are not the minutes I drafted. What I have drafted is different from this. This came substantially from the MD. And the question is, why do you allow the MD control the minutes you have prepared for the board, the entire board? You shouldn't do that. So some threatening you with what? Disciplinary action. Some promise you with a promotion. So what are you looking for? You want punishment or you want promotion? Then the question is, are you a company secretary really? Are you a lawyer? Where is your integrity? So sometimes I say that you don't need any alliance with the MD. You have a duty to the board of directors as a whole. You do the best that you can. Because now if you look at the Companies Act, the company secretary is not a total outsider. If you look at the liabilities,
it affects them.
Yes, you are affected. So if you know the correct thing, why don't you come out and advise the board? But as I said, not in between. You have to be careful. If they haven't come to you, just be quiet, let it go to the board. There, you have a role to play.
It's interesting that you say that when it comes to the board, that's when you have a role to play. Because sometimes the company secretary thinks that they are a member of the board.
No, what you can do is also, it's like you are an eavesdropper and you will hint the board chair. Sometimes you have to do that. You have to alert the chair. Because sitting in the boardroom, most of the time, management is seeking the welfare of the company. But sometimes it's something else. So if you sense anything like that, you can draw the chairman's attention that I saw this, maybe when it comes, look at it closely. What you don't know is whether the chairman will go and tell the MD. That's a problem.
Yeah.
And I know that some company secretaries will lobby other directors. They won't do it directly.
Okay. So, Mr. Ntrakwah, you know how, I mean, you also said it, and we know that when it comes to corporate governance, the company secretary is the one that is responsible for ensuring that board decisions are carried out. From the acts, a company secretary can even be a body corporate.
Yes.
Like the business that corporate profile.
Yes.
Yes. And so at this, in this instance, where you are working outside of the business, the only time you're coming in is when you're carrying out your duties, you're signing documents, you are issuing notices in time, making sure documents are going in time, you're scheduling general meetings and board meetings. How does the company secretary ensure that the board's decisions are carried out in the company? How will I play that role well?
Yes. Don't leave it in the hands of the MD or the board chair, because most of the decisions of the board are directed at the MD or the top executive.
Yes.
So you have to educate your board that at the meeting held on Tuesday, so and so, the board directed that ABCD. You communicate it to the managing director, even though the managing director may have taken down notes at the meeting, because you want a feedback, because you want compliance, and because after the meeting, the chairperson, if the work is being done properly, is not likely to be seen until the next board meeting. You should ensure that the decision of the board is communicated. And maybe, depending upon who constitutes the board, in an open, let's say, one meeting, you can draw their attention that these are my operational lines. If the board has anything to say, that after the meeting, I must communicate. Because some places, they say the board chair must communicate. I don't agree with that, because to my mind, after the board meeting, the board chair has finished business. If the company wants the board chair to do anything beyond the meeting, they normally say it. They normally approve the chair. We have to go and see Mr. So-and-so chair. This one is at a high level, so you must go. And they will take the decision at the meeting that the chairperson should go. Or this particular letter should be written by the chairperson. Otherwise, the common law position is that it is the secretary who communicates the decisions of the board to the management and to persons who must act on them, even including outsiders.
So we will go to the chats. People have a couple of questions have come in. So far, we've had Mr. Felix Ntrakwah with us. He is, even though he is in the firm practice, he's a guru in company law, company secretarial practice. So today, that's why we have him here to come and give us insights on the company secretary's role in corporate governance. Nicholas he says, thank you for the insights on who qualifies as a company secretary. And I was sharing that if you wanted to know qualifications, you find that in sections 211 and 212 of the Companies Act. He wants to know if there are any monitoring mechanisms to ensure efficiency. And he says this because he's witnessed a situation where the company secretary was not available and the chief finance officer, who is a chartered accountant, stepped in to do the work of the company secretary. So I think if I can understand him, I think he's wondering if that can be, and then two, if not, then is there a way we can monitor whether there's a breach in company secretarial role?
Well, the Companies Act allows companies to have deputy secretary, assistant company secretary, so that one person does not hold the company to ransom. So if you are a company secretary and you are not there, they could even ask one of the directors to be the secretary
as a secretary, yes.
on that particular occasion. It is allowed. But who appoints that is the issue.
Yeah.
It should not come from management. Management may recommend, but the decision as to who should act in the absence of the company secretary should be that of the board of directors.
Yes, rightly so, because the board is the one that appoints the secretary, sets out the remuneration. So yes, yeah, it makes sense that it's not management. Okay.
And whoever is going to act as secretary must also know that, like an officer of the company, when the liability comes, you go with the directors. Whether you acted for one day or not.
Yes. That day, yeah. Yeah. Somebody wanted you to highlight more on filing of returns, filing of annual returns.
Well, this is a statutory requirement. It should be done at intervals of 15 months, except in the case of a fresh company,
Mm.
who does it within the first 18 months. Every company should, within an interval of 15 months, file the return. The return is information about the company's shareholding, stated capital, debentures, authorized shares, particulars of directors, particulars of secretary, transfer of shares, changes that have occurred in stated capital will show. If there are new members, that should show. So it's obligatory. Then it should be signed by at least a director and secretary.
And there's also something about the conflict. If there's a director who's acting as the company secretary, that's fine. But when there are certain things that documents that have to be signed, you have to be careful that that person is not signing the two. There should not be a conflict when it comes to the duties. Yeah.
If the thing has to be done by two persons, anyway, the company secretary and the director, you must sign only as company secretary, unless somebody sign, another director sign the place for director, yes.
Mr. Ntrakwah, when you look at corporate governance, really it's about control of the company. How internally, how the board is controlling, how internally there are all these controls. If you look at those that are heavily regulated, how Bank of Ghana is controlling from the outside with their laws or SEC. Should the company secretary be looking at it as a set of rules that is always limiting, or we should be interpreting to enrich the business?
We should be interpreting what?
Well, we should be interpreting corporate governance rules to enrich the business instead of going through checking the box procedures. No, you can't do this because it's against the law. No, you can't do that.
Yes. Maybe that is one of the problems we have. So some people believe it's a question of assembling documents you call corporate governance directives or corporate governance guidelines. We tend to forget about individual and then what goes on in the boardroom. That is where the corporate governance takes place. When you know that Bridget is your sister, and then Bridget is coming to do business with the company, then I am on the board. You come and lobby me. This one is my sister. So because I'm also a director, I have to either stay out or I will not vote. By you coming to lobby me, if you are not there and I keep quiet and sit down there, am I being honest?
Yeah.
It's an area which is difficult to control. It means my mind is already poisoned in favor of your sister.
Yeah. Yeah.
So do I also have an interest? Remote one, maybe. Should I say that yes, colleague director has come to see me about this, and therefore I'm not voting, or I should keep quiet? Or corporate governance. There's a matter before the board. You are the representative of an institution, and the institution has told you what to do when you go to the meeting. Vote in a particular way. But when you have the benefit of all the facts in the matter, and you realize that what your institution is telling you to do is contrary to law, what do you do? Are you going to go because the institution says this is the way you should go? Are you going to go vote in a particular way because that is what the law says? Are you going to vote because, according to your conscience, this is bad, despite the fact that you've been told to vote in a particular way? So you don't have any rules on this. And nobody tells you what to do. But now in the Companies Act, you are required to use your independent judgment, regardless of what your sponsor wants you to do. Can you do that? You're also required, under this new act, to bear in mind the consequences of your actions in the long term. Now, sitting in the boardroom, you have been told, vote in favor. And then you have all the facts before you. And you see this is a bad transaction in terms of the law. It is a bad transaction in terms of your conscience. Yeah. What will you do? And which one will amount to good corporate governance? Going by what your institution has told you to do, or going by the law, or going by your conscience? So no matter what you have been told, well, no matter what you have read, you will see the real challenge in the boardroom.
Yes. So in the boardroom, I mean, we've heard it time and time again that the company secretary is not a member of the board. You are in the boardroom, yours is to advise. Don't take it for granted and start speaking and expressing opinions. So now, having this background, when I walk into any boardroom as the company secretary, what should I expect and what should I never do as a company secretary?
You don't vote to start with. So that should never happen, unless you are there also as a director, which is possible. If you have something to say, don't say it when you have a director on the floor. Seek permission from the chair. Oh. Or you whisper to the ears of the chair. Or you write a short note, because I would expect you to be sitting close to the chair. Give a short note to the chair. The chair may not have adverted the mind to this, and so we'll be happy to see your guidance. But sometimes some company secretaries forget themselves and they chip in unnecessarily. If you have a chair who knows what to do, you can be embarrassed.
You know, some board chairmen have referred to secretaries as scribes. I think that would also be wrong, that they are not there just to write minutes, but also to advise the board. They are there in a professional respect to advise the board on certain things.
That is correct. The old idea of the company secretary is gone, and it went long ago. Mm-hmm. The position of the company secretary has now been strengthened by this Companies Act. So if they are telling you, secretary, walk out and allow us to discuss this. If I'm the one advising you and you don't want me to hear what you are saying, how am I able to advise you? And you are sitting there, highly qualified person, even maybe better than some of those sitting there. If it happens once, find a way of discussing with the chair and letting the chair know that by law, this is what I'm supposed to do, because the chair may not know. So it is not a fight. Politely draw the chair's attention, and it's not likely to happen again.
Now that we've mentioned minutes taking, do you have any advice, short one, so that the rest will come for training for that one? Any advice for minutes taking? If you had to give just one or two.
Yes, take notes at the meeting. And remember that what you do at the meeting is not the minutes. It is the notes. After the meeting, you put everything together. But the long and the short of it all is that it should be concise. It is not everything that you heard and wrote down, which will constitute the minutes. It should be concise, to the point. And if you have a chair who is good and will be summarizing as the meeting goes along, your workload is reduced. But most chairs in this country don't do that. Start drafting your minutes almost immediately after the meeting, because then you will have everything fresh in your mind. And you can even visualize what went on, the gesticulations on a particular topic. You get all that. If you sleep for a while, it's difficult to gather everything and be able to write good minutes.
That's true. One of the first piece of advice that she gave me was that I should be careful of influences of the managing director in my minutes.
Mm. Yes.
If you'd like to comment on that, another kind of politics that's come up in the boardroom.
Yes, especially if you are an employee. The managing director believes that the minutes must be seen before the distribution. And what is worse? Oh, secretary, come. This one, oh, he didn't say that. But even this, why don't you remove it? Especially when there is the management is a subject matter of
yes. And they haven't even done it.
Yes, they will want it out. But they will not dare if they know that you know your job. If you know your job and you do your minutes quickly. So in the in-house company secretary, because you also have to communicate decisions, do your draft quickly to enable you communicate the decision to managing director. And then you treat your minutes.
That's
They'll
true.
be afraid of you. Say, this is a serious woman or man. You cannot interfere.
That's true.
Yes. But when you relax and they see, oh, bring it, let me see, because I don't want the board to see any bad minutes. It's a trick. They want to control what you write, and it is not good.
Mm-hmm. So I had a colleague who was sharing with me that as company secretary, she received an email from a minority shareholder because they wanted to be represented on the board, and apparently they were not. So she communicates to the board chairman, and he is majority shareholder, and then he seems to shoot it down. He seems, he's not particularly interested in the fact that the minority shareholders, it wasn't even just one person, minority shareholders were not represented on the board. And then she's talking to the MD about it, and the MD says, the MD is also inclined towards the board chairman. So the MD says, you know what, let's just do what the board chairman is. So she's now struggling and in a difficult place because as the company secretary, I know that I'm supposed to even call a meeting when a minority shareholder requisitions a meeting or certain, and now she's stuck because the managing director and then the board chairman are not interested in the needs of the minority. What advice would you have for a company secretary who's also an employee in this instance?
Well, they better tell the minority to seek advice and act on the advice of the lawyers.
Okay.
Because the minority can also propose an agenda for a meeting.
Yes.
And if it will not be taken, as you said, the minority can requisition a meeting. But the secretary should not take it upon himself or herself to try to do something. You see, your chair is not in favor. MD is not in favor. But the minority has a right to propose something for discussion. So please, I'm in the middle. See your lawyers to advise you.
That's fine. That's very good advice. I hope she's here. She's listening. And we'll upload this recording on YouTube, on our YouTube page, Lawyers in the Corporate Space, so that if you want to recap this, you can get a chance to. Somebody has a question, and then she wants to know that if I'm a director appointed by a shareholder, can I ask contrary to my shareholders' decisions while in the boardroom?
Oh, why not? This is why I introduced this aspect. The governance in the boardroom. Your shareholder says, when you go, vote this way or propose this. And you see that it is wrong. And you go on and do it. And this is what happened in the case of PS Investment, which led to litigation lasting for 14 years. And only for the Supreme Court to set aside everything what that was done. This was government wanting to sell shares contrary to regulations. Government needed money. Go and do it. They go to the boardroom. They see it is wrong because another shareholder had tried to do that and they stopped that shareholder. So what is new? The same regulation. But this time they said, no, we cannot go against the government. So they went contrary to the law. 14 years of litigation, and the whole thing was set aside. What did they achieve? They should have been able to say, it is wrong. Let us do it properly and seek advice on the correct way to do it. Everybody would have been saved.
Okay, there's another question here. It first starts with a comment. One difficulty an employee, an in-house lawyer, or acting as a board secretary faces is the corporate politics. And for want of a better word, people attempting to bully you in the work that you do. What advice do you have for such in-house lawyers or employees who insist on professional independence as the lawyer or as the company secretary and, insisting on my integrity? How would you advise such a person? I know you've said it. There have been undertones of it throughout how somebody could, but if you could please reiterate it one more time for Frederick Sampson, who's asking.
I know it is not an easy situation. You are an employee, you are looking for your salary, but then you are given one position which gives you sleepless nights. If you are not lucky, soon after a board meeting, your own colleagues are coming to you to find out how did the meeting go.
Yes.
Are you going to tell them the decision of the board? If you don't tell them, oh, but I thought you were my friend. This is not friendship business. As a company secretary, you are at a certain level. As I said, the possibility of you even becoming MD one day in the same establishment is real. So where is your integrity? So you want to keep your people off. But sometimes it is coming from management.
Mm.
Oh, there is a training abroad. Let me pretend to be the MD. And I call Bridget. You are the company secretary. There's a training abroad coming in 2 months. Bridget, are you interested? After I have asked you this question, maybe the same day or the next day, Bridget, can I see your minutes you have drafted?
Yes. I'm compromised.
You see, but if you know your standard, so the people who are against you because of your integrity will still admire you. You may
That's
not.
true.
Yes.
That's true. That's true. Thank you so much. I don't think we have any more questions here. So we'll do the parts where I enjoy the mentorship, which is also the reason why we started Lawyers in the Corporate Space. With all the wealth of experience that you have, with all the boardroom experience, encountering different company law cases and things like that, what would you advise an in-house lawyer? What advice would you give an in-house lawyer in how to better themselves, make themselves stand out in the work that you do?
I think whether you are even in-house or external,
Generally.
there's a lot of learning to do. Do not restrict yourself to the law or the profession you belong to, because you are an important part of management. Read beyond the confines of your profession.
Know the business.
Yes, you must know the business. Be prepared to take higher responsibility in the establishment. Consult others. If you have any challenges, ask somebody, a colleague who may know. And as I said, if you pay attention to the characters in the boardroom, and you're able to pick up the knowledgeable and experienced directors, there's a lot to learn from them. You may get somebody who is not a lawyer, a director, but has experience in a particular area of the law and makes good contributions to meetings. You learn from such persons. You are in the boardroom as a student and a teacher at the same time. That is, whether you are a director or a secretary, this is precisely what goes on. You're a student because you are picking bits and pieces from the directors in the boardroom. And there may come a time that you may also say something that others will pick from you. Either they know or they may not know. If they know, your contribution may have thrown more light on the matter, so they like it.
Thank you. And I have just one last question. What courses would you recommend for us in-house lawyers to do?
On company secretarial practice?
So generally, to enrich the work that we do.
In-house lawyer. You may not be doing courtroom practice at all. But if you know that embarrassment can come easily from litigation, therefore, you should have a certain step, or let's say determine the steps that should be taken. Let's say if a case is in court, what should we do? If there's an application, a motion in court, there's an application for, say, injunction. You have to plan ahead. Don't just leave it to the external lawyer. Be proactive. What I have seen is that some in-house lawyers, once they refer the matter to the external lawyer, that is it. Find a way of following up. Because can you imagine you sitting in your office and you have bailiffs who have come, they are taking your MD's car after judgment. Can you say it is the fault of the external lawyer? Who is a lawyer? Did you follow up the case? Did you hear about the judgment? Did you instruct that they should appeal or file a stay of execution? Or you just, okay, if I hear from the external lawyers, then I'll advise management. It may be too late. So while you are not practicing in courts, the basic procedure in the courtroom, you must know.
Okay.
And you
So
must
I should go back to pick my CI 47.
Yes, swiftly.
Yes.
Yes.
And I remember that you also used to advise on, I think, was it project management?
On
Project management.
yes. Yes. And now it's like a basic requirement. Outside the country, this is very common. Lawyers are training themselves in project management because the way we handle clients' businesses is not the best. So a week, 2 weeks training, they do it in Ghana, Legon, Gimpa, yes. From there, and learn 1 or 2 disciplines outside the law. Are you interested in, say, finance, economics, politics?
Good as well.
And let me repeat that you stand in a position where you can easily become MD one day. And so learn something about management.
That's true. That's true.
And what I've also noticed is that sitting and interviewing people for employment, they look at your degrees, all right. They look also particularly at the short courses you have attended.
Yeah.
You see whether after you finish school, you've done anything to improve yourself.
That's true. Somebody, I think, let me take this one, then we can end. Somebody wants to know if there's any professional qualification training for persons who want to become company secretaries.
The professional one, I believe, is the foreign one.
Mm.
Yes. But Corporate Law Institute, we do it. We train company secretaries.
Okay. So, Mr. Marley, please answer your question. I have posted the flyer for the next Corporate Law Institute training, Overcoming Challenges in Company Secretarial Practice. I posted it in the chats and their email address and phone numbers so that you can reach them. And also the title of Mr. Ntrakwah's book, The Companies Act 2019, Act 992, Obligations, Defaults, and Penalties. So yeah, a copy, there's a contact number there, and a copy goes for 200 Ghana cedis. I'm going to get my copy, I can assure you. I'm very sure to be worth the read. Thank you so much.
Even
Yes.
your directors,
can also buy through.
Yes, your directors.
Yes, it was good for them to also know the penalties and obligations. Okay.
And they take you serious.
That's
Those who are not
important.
able to prepare their financial statements, if they get to know that it is their duty to take steps to secure the preparation and circulation of accounts, otherwise they face prison term. Yes. So
We'll
fine.
take it seriously.
They will take you seriously. Yes.
We'll take it seriously. Thank you so much, Mr. Ntrakwah, for making this time. Thank you. Really, really appreciate it. And I can assure you we'll come again. This will not be the last time. We'll come again for another kind of training.
All right.
Like I always encourage everybody, please let us know what kind of trainings you would like to have, what topics you would like us to treat. And we will upload this video on YouTube, on Lawyers in the Corporate Space, on YouTube, so that it will be accessible to everybody who could not participate. We had participants limit restriction. Unfortunately, I'm sorry that I missed that. We'll rectify it so that for the next session, we won't have to struggle with numbers, so that as many people who want to join will be able to join. We had 100 people cap. So unfortunately, other people were trying to join and we were not able to. So we'll try and make sure that this doesn't happen. Please give us feedback. Feedback is the breakfast of champions. We'd like your feedback. Please give us feedback. You can find me on LinkedIn. You can, whether on social media, or if you have my private number, that's also fine. And please give us feedback, how we can make these sessions better, more improved. And if you have questions too, please send them right ahead. So Mr. Ntrakwah, thank you once again. Thank you everybody for joining, for making time to join. Thank you so much. I really, really appreciate it. And we will not be having these sessions without you. So thank you. Thank you, everybody. Thank you all for joining.
It's been a pleasure being with you.
Thank you so much. Thank you. I'm glad it was worth your time. All right. So thank you so much. We're ending the meeting now. Thank you.